A good morning once again to our esteemed president in the person of Professor Joan Umbagu, our noble ESCOs, and my dear colleagues. I'm indeed humbled to be given this privilege to deliver this topical issue on seismic shift, the impact of Evidence Act 2011 on electronic and digital evidence in forensic practice. The admissibility and handling of electronic and digital evidence has become paramount in Nigeria. This has seen over time and in recent times, mainly caused by the proliferation of electronic devices and digital platforms, which has irrevocably altered the landscape of criminal and civil litigations. It would be worthy to note that prior to the enactment of the Evidence Act 2011, now amended, the legal framework for dealing with electronic evidence was largely fragmented and often relied upon by, we were using common law enactments to back it up in understanding how the Evidence Act would work hand in hand with the way evidence is presented in court, it's gathered, it's collated, it's stored for proper use by prosecutors and judicial officers. It has also affected the way statutes and principles have been interpreted. The Act, in its recognition of the unique characteristics of electronic records, represents a seismic shift, offering a more structured and contemporary approach. Thus, the Evidence Act 2011 now provides a unified legal framework for the admissibility of evidence with respect to electronic and digital evidence in Nigeria, but its implementation is uneven around the country due to regional disparities and challenges, some of which I'll mention, which includes infrastructural gaps. Urban areas generally have facilities, they have easy access to internet, cloud, power supply, forensic facilities, more than rural areas. This also affects the ability to effectively identify, collect, preserve, and analyze digital evidence. Example of which is securing stable internet. There was a situation in which at one time I was court examining a police officer, and when he was asked on how he got his the pictures he presented as evidence, as exhibit before the court, he did inform the court that, okay, because of where he was, he used his phone to snap the scene of the crime. And after he snapped the scene of the crime, he saved it via Google Cloud. And after he saved it, he got to the office. There was the system that was working, that was used by his department, the legal department. And he stored the information on it. And from there, he printed out the pictures via Bluetooth. He printed pictures which were used, which were being presented as exhibits before the court. But now it now boils down to the prosecuting or the defense counsel in establishing, was a foundation laid on how that document was brought about with respect to the functionality of the phone that was used, the type of phone that was used, what kind of instrument or what kind of machine was used to store it before it was taken back to the office. You can see that the police officer had moved from a particular scene with the evidence because we don't have enough facilities in the Nigerian police. So we are getting there by God's grace, but we don't have enough facilities to take proper identification of crime scenes. So it was really put in the box, and because proper foundation was laid to how the evidence was gotten and how he stored it before it was presented to court, it was allowed to slide. But because it works in that court, doesn't mean that it will work in a rural area where he might not have access to internet to store the information he snapped immediately from the scene before taking it back. It may be in a rural area where the scene occurred. He has to bring it back to the state command. State command will now present before they move it to the Ministry of Justice for presentation and for sorry before the original case file is totally prepared and ready for to be used as evidence in court. So we are having the issue of infrastructural gaps. Again, we have capacity and training. There is uneven distribution of expertise in digital forensics across Nigeria. Likewise, training and digital forensics with reference to the Evidence Act. This has been observed between prosecutors, judicial officers, law enforcement agencies, because now we have to create a form of synergy in, okay, I've taken the scene. People have, okay, let me give another instance. With respect to the issue of capacity and training, I handled a matter to which it was a rape incident, and the police investigator that went to the scene was able to get hold of the underwear of the prosecutrix, which had blood stains, and it was alleged that okay, the other liquid found on the underwear was semen belonging to the suspects at that time, the accused now. But before they could bring it from the local government, which would even take almost 3 or 4 hours before it gets to the state command, the way it was stored, as at the time I was presenting this exhibit before the court, it was like 2 years after. Rats had eaten deep into the underwear, and but before I could present it, while taking it to the, I knew that this wouldn't slide because the form of storage of this evidence, it was totally wrong. The time it took, no DNA was taken with respect to whether it was actually the semen of the accused person. So I had to bring in, I was lucky to talk to my bosses at that time, and an expert was brought in to help us identify what we could use. A forensic expert was brought in to help on how we could tidy the evidence that was so germane, and that was the only thing we had because the prosecutrix was a minor. Again, there is issue of criminal regional crime patterns. Different crime regions are faced with distinct forms of cyber crimes, which can be more prevalent in the urban areas than in the rural areas. So with respect to digital evidence and Evidence Act, the way it will be presented and the court to which it is presented, it goes a long way in understanding how these evidences will be brought before the court. The influence of the acceptance of digital evidence in the rural areas with respect to maybe information stored via data, the way it will be presented in the urban area and bringing such information from the rural areas, it's something that is still being worked on, and we feel that with the help of the Forensic Society, we are getting there. Also, we have the issue of logistics challenges. Effective management of digital evidence is hindered by limited storage facilities. There is need for interagency coordination between the police, EFCC, DSS, and judiciary, and the challenges in maintaining the chain of custody, especially in remote or completely isolated areas. For instance, in the Northeast, the way evidence would be gathered in an area that is prone to violence, you can't get enough data to be able to use it as evidence against the people, the suspects that were arrested. Because, okay, maybe while the police officer were running, some of the items he saw, maybe bullets that he had taken, might have fallen down. Because, okay, he's in this rural area. What happens in Borno? the way evidence to be gathered in Borno is totally different from the way it to be gathered in Lagos State or Ogun State, for instance. Also, with issue of the pipeline vandalization, there is need to bring in forensic experts very versed in such areas to deal in gathering evidences, storage, and so on. Also, the forensic community in Nigeria is actively adapting to the Evidence Act 2011, especially regarding electronic and digital evidence. This adaptation is marked by growing awareness and training, which we thank the society and some other organizations too that are coming up, that there is increased recognition for the importance of digital evidence, leading to more specialized training in digital forensics and forensic computing, mobile and network forensics, and the legal aspects of the electronic evidence on how to educate the judicial system, the law enforcement officers on how to gather information, evidences, the storage, the presentation before the court. Also, there is increased growth in specialized units. Like I observed that in the Ogun State Nigerian Police Force Command in Elewero, they now have a specialized unit that is involved with gathering of information with respect to cyber crimes. They work hand in hand with DSS and EFCC, and thanks to the society as well that we are moving forward. Everybody is gaining more knowledge, and the judges who are being educated, there is training, and it's a continuous thing on how information is gathered and how it will be presented, and without infringing on the fundamental human rights of the suspect or the accused, as to say. Then there is more understanding with respect to collaboration, because the judiciary now sees the need for forensic experts to be brought in to understand more of data collection, electronic evidence, digital evidence now in courts. Also, expert testimonies are now being used. They are now taken as more valued than what a law enforcement officer or a counsel is presenting before the court. When the expert is brought in, a forensic expert is believed to be more versed, more enlightened, more exposed, and will be able to educate the court. Even the litigants in court are now getting more education on there's need. Let's get an expert involved. We are even using it now in the political scene in Nigeria right now with respect to thumbprints, in as much as we do not have enough fingerprint archives, likewise the dental archives, but we are getting there. Also, professional bodies are developing guidelines for handling digital evidence, aligning with international standards and the Act's requirements, so that all data gotten or information is well presented to the court, and justice is seen to be done. Also, the legal landscape surrounding digital evidence in Nigeria with reference to the Evidence Act 2011, while being the primary legislation governing the admissibility, doesn't operate in isolation. Several laws now intersect, and you can't just make use of the Evidence Act alone. You have to intertwine it with some other laws in Nigeria right now, which has also met international standards. It creates like a harmony, which it makes it more logical for forensic experts to present their case in court. One that is most prominent is the Cybercrime Prohibition Prevention, it is launched Act 2015. The interplay with Evidence Act, the Act is perhaps the most significant. This Act, that is the Cybercrimes Prohibition Act 2015, Act is perhaps the most significant piece of legislation directly related to digital evidence. It creates offenses related to cyber activities and outlines procedures for the investigation and prosecution of this crime. With reference to the Impact on Evidence Act, the Cyber Crimes Act specifies the legal framework for obtaining electronic evidence in cybercrime investigations, including search warrants for digital devices and data, prevention of orders, and the admissibility of computer-generated evidence in cybercrimes. It complements the Evidence Act by providing the substantive criminal law related to digital activities and specific procedures for investigation. I will point to Section 38 of that Cybercrimes Act 2015. It deals with the admissibility of electronic evidence, and the provision works in tandem with Section 84 of the Evidence Act. Section 84 of the Evidence Act states the way and manner to which evidence is presented, especially with respect to digital evidence, before the court. So Section 38 of that Cybercrimes Act lays further foundation on how the cybercrime data was obtained. Is it through the laptops, through the phones, through bank statements? How everything is collated, how it is stored, how it is presented before the court without infringing on any law. With respect to that section,
Hello,
ma,
so sorry.
let me quickly try and round up. Let me quickly try.
Yes,
That
yes,
section
you have to.
38 specifically states that all financial institutions must be able to keep data for at least 2 years. Any financial information gotten must be kept for 2 years. We have the National Information Technology Development Agency Act. We have so many acts. EFCC, we have the CBN, we have the International Corrupt Practices and Other Related Offences Commission Act. They all work in tandem with the Evidence Act in seeing that electronic and digital evidence is properly managed in Nigeria. In conclusion, the Evidence Act 2011 is the cornerstone for the admissibility of electronic and digital evidence in Nigeria. The application is significantly shaped by its interplay with other legislation, and the understanding and interconnected legal landscape is crucial for forensic experts, legal practitioners, and the judiciary in effectively dealing with digital evidence and legal proceedings in Nigeria. I believe I've been able to convince listeners and to a level of understanding on how there is the interplay between electronic and digital evidence in forensic practice in Nigeria. Thank you.